Welcome to Debt Free in 30, where every week we take 30 minutes and talk to industry experts about debt, money, and personal finance. I'm Doug Hoyes. Today we're going to talk about student loans, and specifically what happens to student loans if you go bankrupt, and how you can use the court process to discharge student loans. First, some background, and this is important if you're a student or if you are a parent or grandparent of a college or university student with student loans. Under current law, if you go bankrupt, a government-guaranteed student loan is only automatically discharged if you have ceased to be a student for at least 7 years at the time of your bankruptcy. So if you got a student loan in 2010 and graduated in 2014 and go bankrupt in 2015, your student loan does not automatically go away because you have not been out of school for more than 7 years. It doesn't matter when you get the loan. All that matters is when you cease to be a student. The only exception is the hardship rule that says that if 5 years has gone by, you can go to court and ask the court to wipe out all or part of your student loan, as a result of the bankruptcy as well. To do that, you need to go to court, and court generally means you hire a lawyer to represent you. So how does that work? What's the process? To find out, I'm joined today by a lawyer who has appeared in court many times on student loan related matters. So let's get started. Who are you? Where do you work? And what kind of lawyer are you?
I'm Dan Veinot, and I'm a partner at Duncan Linton here in Waterloo. And I practice commercial litigation with an emphasis on bankruptcy law.
Great. Well, thanks for being here today, Dan. I appreciate that. And yes, we are recording this here in Kitchener, Waterloo. You have appeared in court here in Kitchener, but also in Toronto and London as well. Is that correct?
That's correct.
So you've got a pretty good understanding of how the court system works with respect to this in the Ontario area. I want to state at the start that we are not giving legal advice on this show because every person's situation is different. We're giving general advice on how the law is generally applied, but if you're listening to this and you're thinking, boy, I need some help with that, then you should speak to a lawyer. In the show notes, we will put links to Dan, his website, how to contact him if you want to get in touch with him directly. Our website address is hoyes.com. That's HOYES.com. And if you just do a search for podcast or student loans, you'll be able to find this. So let's start with what may seem like an obvious question. I said in the introduction that if you go bankrupt or file a consumer proposal, a student loan is only automatically discharged if you've been out of school for 7 years or more. What does 7 years mean?
7 years from the ceasing to be a full-time or part-time student seems like an easy answer, easy question.
Yeah, I mean, my last exam was on May the 10th, so I count 7 years from May the 10th, and that's 7 years. What's so hard about that?
That's not how the law works. In fact, depending on the province you're in, or the federal obviously acts throughout Canada, but depending on the province you're in, the last date of study is a term of art in terms of the legislation. So typically it would be the last day of the month in which you studied. So it wouldn't necessarily be the June 10th when you wrote your exam. It wouldn't necessarily be June 20th when you graduated. It would be perhaps June 30th if that was the end of study date.
So generally it's going to be the last day of the month. And so what you're talking about here is the end of study date, and that's the date that matters. So if my exam was on the 10th of May, let's say, my end of study date is probably May the 31st.
That's correct.
But not necessarily because, who knows? We're not the ones who make up the rules. We're not the ones who interpret them.
That's correct. And it can vary depending on the circumstances. For instance, we've had a case where the individual left their studies early. So it wasn't necessarily the last day of that month. It was actually for that period. So let's say the term ended at December 31st. That was actually their end of study period.
So if they were to leave school in October,
likely it would be the December 31st.
Okay.
Provided that it is a term semester that ends at the end of December.
If you're a conventional student, you finish your term, you do your exams, you graduate, then it's a little simpler to figure out. But if you had to leave school partway through a term, perhaps for medical reasons, had to go home and take care of a sick parent, you got a great job and said, forget about school, I'm going to go make some money, the end of study date could very easily be the end of the term, not the end of the month that you last were in school.
That's correct.
So have you ever run into a case where someone thought, oh yeah, I know this is the last day, and they go bankrupt, and they find out, I was too early? Has that ever happened in real life?
Absolutely. We've seen it a number of occasions. The most shocking example or pressing example that comes to mind was one where the individual was 1 day late.
1 day late.
So essentially, if they would have waited another day, filed their bankruptcy, they would have been outside at that time it was a 10-year period, but for our purposes, it would be the 7-year period that we're talking about.
Wow. And yes, the rules have evolved in this area. It used to be that there was no special rule for student loans. They were just like every other thing. Then the government brought in a 2-year rule. Then they upped that to a 10-year rule. And then back in, I believe it was either the 2008 or 2009 amendments, they lowered it to 7 years. So, but the process has really been the same. It's just the number has been different. So we're recording this in 2015, in the summer of 2015. So if you happen to be listening to an old version of this podcast 5 years in the future, then you might want to check to see if the government has changed the law again, which is, I think, quite possible in the future. But as of today, it's 7 years. So in that particular case, the guy goes bankrupt. It turns out he is 1 day short, which means his student loan is not automatically discharged. So what happened? Why do you know about this case? Why did you get involved in it?
We became involved because they were trying to have their student loans discharged under what we call a hardship application. And that's under the Section 178, 1.1 of the Bankruptcy Insolvency Act. And that deals with an application to have your student loans discharged after the 5-year period you talked about earlier. Okay,
so let's talk about this then. So normally it's 7 years, but there is a special rule. We call it the hardship rule, but you're right. It's part of Section 178 of the Act, and Section 178 is the section of the Bankruptcy Insolvency Act that goes through a whole bunch of things that affect your discharge. That's where those provisions are, and that section says, we got this special rule. If it's only been 5 years, you can go to court and convince the judge or the registrar to get rid of either all or part of your student loans.
Correct. And in most cases, it's actually not just been 5 years. In most cases, like we talked earlier, you need to be discharged, or you need to be a bankrupt first.
Right.
So in some cases, you could actually apply during the course of your bankruptcy. Most often we see it, the person's been discharged, and they're a couple years down the road, they're still having continued financial difficulty paying their day-to-day debts, let alone their student loans that continue to be with them because they weren't discharged during the course of their bankruptcy.
Yeah, and that's a key point you made there, that we are talking about bankruptcy legislation here. So if you have a student loan and you can't pay it, you can't just go to court and say to the judge, hey, can you make it go away? It's been 5 years or 7 years. No, you have to have gone bankrupt first or filed a consumer proposal first. Am I correct on that? That the rules are essentially identical, whether it's a bankruptcy or a consumer proposal, the 5-year period, the 7-year period, whatever.
Correct, and that's a very good point. It does apply to consumer proposals just as much as it does to a bankruptcy.
So in the particular case you're talking about, the guy goes bankrupt, thinks his student loan's going to go away, but it turns out he was 1 day short, so it isn't. His bankruptcy ends. He gets his discharge because he did everything he was supposed to do, but his student loan is still there. It still exists. They can still pursue him for money. He still owes the money. So he then went back to court, obviously with you to help him, to say to the judge, hey, you know what, judge, this isn't fair. I can't pay my loan. And of course, the judge said, well, fairness really doesn't have anything to do with it. There's a specific provision in the law that says if you are suffering hardship, then the court has the discretion to either make the loan go away or waive it or leave it. So I'd like to get into what is this hardship? How does it work? What are the requirements? What we're going to do first is take a quick break, and then we're going to come back and talk about financial hardship when it comes to student loans in a bankruptcy or consumer proposal. My guest today is Daniel Veinot, and you're listening to Debt Free in 30. We'll be right back.
Looking for information on budgeting, debt consolidation, credit counseling, debt management, and debt settlement? For unbiased advice, go to moneyproblems.ca. the website for Canadians with money problems who want money solutions. moneyproblems.ca.
We're back here on Debt Free in 30. My guest today is Daniel Veinot, who is a lawyer with Duncan Linton in Waterloo, Ontario, and we're talking about student loans. Before the break, Dan, you were explaining that you can go to court and have your student loan discharged if the regular process didn't discharge it. So in a bankruptcy or a consumer proposal, a student loan is automatically discharged, provided everything else goes according to plan, if you've been out of school, you've ceased to be a student for 7 years. But there's a special rule that says, well, actually, after 5 years, you can go to court and ask the court to modify or eliminate your student loan. So you have to have gone bankrupt, and 5 years have to have transpired. So instead of 7 years, it's 5 years since you ceased to be a student. In most cases that you've been involved with, the bankruptcy's already over. I've been discharged, but I'm not able to make these payments. So it could actually be 6, 7, 8, 9 years later, but because the student loan wasn't discharged, you go to court. So, and typically you're going to have a lawyer do this for you, because unless you're familiar with all the court forms and procedures and how to file your motion materials and all the rest of it, it's generally better to have someone who knows what they're doing do it. So you are representing the bankrupt who wants this to use this hardship provision. There are, I believe, 2 different criteria that have to be met in order to get the court to agree. So point form number 1 is,
has the party acted in good faith with respect to the loans?
Okay, good faith. And then the second point is
continued financial difficulty.
Okay, so let's break those down then. What does good faith mean? What does it mean that I've acted in good faith?
Well, there's a number of factors that the court will look at, and for instance, whether the money was used for the purpose it was loaned.
Okay, so if I got a student loan, bought a car, never went to school, that doesn't sound like good faith.
No. What the court's looking at, did you use the money loaned to pay your tuition, to pay your books, to pay, your residence if you were living in residence? Those are the types of things that the court looks at, not the example like you mentioned.
Right, okay.
I bought a car and I never went to school. I dropped out after the first week of classes.
But I got a great car out of it. So that seems pretty simple. Are there any contentious issues related to good faith?
There are. I mean, sometimes one of the primary concerns that the government has is whether or not the party actually completed their studies. That will often be something. And that leads us to a second aspect of good faith, is whether the party actually completed their education and derived some economic benefit from it. So were they able to actually find employment in their field of study? So if they studied business, or were they able to find a job in the business, whether that be an accountant or in that field of study?
So if I went to school to become a doctor, I now am a doctor and I'm getting paid like a doctor, the court is more than likely going to say, yeah, you know what, you should pay that loan back.
Yes, that's typically how the courts have looked at it, if you are able to gain some benefit from that education. That's not the only determinative factor. There's other factors as well, including did they use reasonable steps to pay their debt? So prior to filing bankruptcy, or even after filing bankruptcy, and because the loans are still there, did they take steps to actually pay? And I mean, we're not talking perhaps the full amount of the monthly payment that's due, but we're talking about a reasonable amount that they could pay based on their income.
So if 5 years have gone by and I've never made a single payment, I better have a good reason for that.
Right. You better have, I was living on minimum wage and there was no extra money for me to be able to.
It was impossible. Whereas if I did have some kind of job, and I mean, if at least I was making a $50 payment or a $100 payment every month, then that is going to help my argument that I did the best I could. And that's kind of what good faith is. I did the best I could is really what you're looking for. If I went to school, to be a hairdresser, and the private college I went to went out of business.
That's something we have seen. And sometimes the court will say, you know what, because of the loss of reputation, perhaps you're having difficulty finding a job because of that school closing its doors, or perhaps you weren't able to complete your education because of that. Going back to one of our earlier topics of, did you complete your studies? Those would be things that the court would consider. And we've actually seen that where, colleges have gone out of business, and I had an individual who was actually working in the technology sector, and because of the fact that the college went out of business, it wasn't looked as upon as
not as good an education as if it was a college that still existed. So not really my fault that the college went out of business. The court's going to be a little more lenient. So, okay, are there any other points then related to good faith that we need to talk about?
Yeah, another big one, I think, and an important one is, has the party actually looked into interest relief? Because students can apply if their financial means do not permit them to make monthly payments. So they're allowed to apply for interest relief. And the court looks at, did you take advantage of that interest relief? Whether you applied and didn't qualify, because the cap is fairly low, surprisingly, for not qualifying for interest relief. So the court looks at that, and did you maximize that? So, depending on the province you're in and the circumstances and timing of when you finish your studies, you're eligible for interest relief. So they look at, did you apply for those means, those other options, to supplement things.
Yeah. So have you done what you could have done? Did you try to get a job? Did you try to make payments? Did you apply for interest relief? That's kind of the whole good faith argument. Okay. So let's take a look at the second one, which I think is probably a bit more contentious and maybe a little more confusing. Continued financial difficulty. You have to demonstrate to the court that if your student loan doesn't get wiped out, you're going to continue to suffer financial harm. What's that all about? What does that mean?
And is absolutely the more difficult part of the test. The courts have not sent a rigid regime of how do we interpret that. But generally speaking, the courts say, we don't look 10 years into the future to say, in the next 10 years, because
nobody can look that far ahead.
Right. No one has a crystal ball. But they typically say, in the next 2 or 3 years, where are things going to be? And some examples we've seen are, for instance, veterinarians who were doing internship, or their extra schooling that they need to before they could get their full license. That was one of the aspects we've seen. And the court said, well, for the next 2 or 3 years, this person's still not going to be a full vet. And they're not going to be able to make the income that was expected. And they have discharged those loans in some instances such as that.
So if my education is the kind of thing where, great, I've graduated now, but it's a long, slow road to ramp up to full income, because there's a long apprenticeship period, studying period, whatever, that may be an argument that, yeah, I am going to have continued financial difficulty. So, okay, that kind of makes sense. Any other components related to that you would have to demonstrate to the court?
The court does look at whether or not, and I disagree on this aspect to some degree, as to whether or not the individual has surplus income, and this is under for instance, while they're bankrupt. We talk about surplus income and whether they have surplus income. And the courts have looked to see whether or not the family has a surplus income or whether that individual has surplus income. We've argued and successfully argued that shouldn't be taken into account, although there's courts that have said we do look at the surplus income. But my position, as I've put forward, and it has been accepted by the courts in some instances, is that really that surplus income is during the course of your bankruptcy. And for the average bankrupt, without any special circumstances, you're probably looking at 9 months if it's a first-time bankruptcy. So I'm saying, it's to keep you on a tight budget during the course of your bankruptcy, but you shouldn't be penalized for the next
forever.
Right, 5 years or so. Yeah. That is something that the courts do look at, though, to some degree. So that is a factor, to consider. But the courts have interpreted that in different ways.
And I guess this is kind of a classic example where having a lawyer who has been in court before, who understands what the court is looking for, is to your advantage, because when the judge says, well, you have surplus income, so I'm going to make you pay, this, you can say, well, yes, that's true, Your Honor, but here are other cases where you've ruled differently, or the courts have ruled differently, and here's why it's the fair and just thing to do in this case. And as a result, you can get the desired result, I guess. And am I correct in saying that the court can either wipe out the student loan or lower it or do nothing? Those are really their three choices?
Actually, they only have, they have three options. They can either grant the application, which means the student loans are discharged completely, or they can deny the application, which means the student loans are there in their entire amount, or they can adjourn the application. In some instances, they're not satisfied, and that
they want to see more paperwork, more proof that you're suffering hardship, that kind of thing.
That, and sometimes they also want to see what the future will bring. So, for instance, someone may come in and I've had this happen where they've recently lost their job and they say, well, I'm not sure if I'm going to be able to find a job in my field. I was making, reasonable money and there was a prospect of me advancing, but I've recently lost my job to no fault of my own. And the court says, well, it's been 2 months and you haven't found a job, but we're not satisfied that you're not going to be able to land on your feet and find another job to replace that income. So sometimes it will adjourn it. It could be months. It could be even a year in some instances where they will adjourn it and ask the party to come back and reassess it at that time. But they can't reduce the amount, unfortunately. And that's
so it's an all or nothing deal then. So, okay. And I can see why the court would adjourn it, come back in a number of months. Yes, we now see that what you said is correct, so the loan is wiped out, or no, your circumstances are way better, no, it isn't. So, great. Well, I appreciate that, Dan. That's a good overview of how the court process works when it comes to a hardship provision. We'll be right back to wrap it up. You're listening to Debt Free in 30.
What are the warning signs of debt problems? Where can I find a free online debt options calculator? Where can I get free ebooks and guides? Find all the answers at moneyproblems.ca, the website for Canadians with money problems who want money solutions. moneyproblems.ca.
You're listening to Debt Free in 30. Here's your host, Doug Hoyes.
Welcome back. It's time for the 30-second recap of what we discussed today. On today's show, Daniel Veinot, a lawyer who appears regularly in bankruptcy court, explained that it's possible to discharge a student loan that is between 5 and 7 years old when you go bankrupt under the hardship provisions of the Bankruptcy and Insolvency Act, and he explained the 2 requirements for a successful hardship application: good faith and continued financial difficulty. That's the 30-second recap of what we discussed today. So, is it really necessary to hire a lawyer to represent you in court in a student loan hardship hearing? No, it's not absolutely necessary. You could do it yourself, but in my experience, your chances of success are much higher if you hire an experienced lawyer who knows what the court is looking for. The rules and the paperwork are complex, so in most cases, a good lawyer is money well spent. That's our show for today. Full show notes are available on our website, including details on what happens to student loans in bankruptcy. So please go to our website at hoyes.com, that's HOYES.com, for more information. Thanks for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.
If debt problems are keeping you up at night, if collection calls leave you afraid to answer the phone, it's time to end the cycle. You can do something about your debt. Call Hoyes Michaelis today at 310-PLAN.